Hi, I'm Courtney, and today I will be explaining the Family and Medical Leave Act to you, which is often referred to as FMLA. Throughout this presentation, we will learn about the following topics: background information, federal law counterparts, state and family medical leave laws, how FMLA laws are enforced, violations of the law, consequences of violating the law, and suggestions for being compliant. You may be wondering what exactly FMLA is all about. FMLA was signed by President Clinton and enacted August 5, 1993, and guarantees employees 12 weeks per year of unpaid leave for certain family and medical reasons. As part of FMLA leave, employers must also continue to pay for employee health insurance as they normally would. An employee is eligible to take time off using FMLA if their employer has 50 or more employees, they have been employed by the employer for at least 12 months, they have worked at least 1,250 hours in the last year, and they are requesting time off for an approved family or medical reason. Approved family and medical reasons include having a serious medical condition, pregnancy or care for a new baby. This includes care for adopted and foster children, caring for a child, spouse, or parent with a serious medical condition, caring for a wounded service member or veteran, or if you need to take time off due to circumstances arising from the deployment of a service member. You cannot take time off using FMLA for minor health conditions such as the common cold, flu, or an upset stomach. Next, we are going to talk about the federal counterparts to FMLA. There are 4 federal counterparts that we are going to discuss: the Americans with Disabilities Act, the Uniformed Services Employment and Reemployment Rights Act, the Pregnancy Discrimination Act, and the Jury System Improvement Act. Once the 12 weeks of FMLA benefits run out, depending on the circumstances, an employee may qualify for additional support through the Americans with Disabilities Act. Uniformed Service Employment and Reemployment Rights Act provides extended benefits to individuals who require time off from work due to their service in the armed forces. The Pregnancy Discrimination Act prevents employers from discriminating against employees based upon pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. While this act does not require employers to provide paid leave, it does require that employers offer the same benefits that are offered to individuals with other medical conditions to the employees. These benefits may include sick leave, disability leave, and light-duty assignments. The Jury System Improvement Act protects persons who serve on federal juries from discharge, intimidation, or coercion by their employers. At this point, you may be wondering, does the state I live in also have family and medical leave laws? There are 14 states: California, Connecticut, Hawaii, Maine, Massachusetts, Minnesota, New Jersey, New York, Oregon, Rhode Island, Vermont, Washington, Wisconsin, and Washington, D.C. that offer unpaid family and medical leave benefits. Currently, 3 states, California, New Jersey, and Rhode Island, offer paid family and medical leave. Beginning January 1, 2018, New York will become the 4th state to offer paid family and medical leave benefits to their residents. Connecticut, California, Massachusetts, Oregon, and Vermont all offer paid sick leave benefits to their residents. There are also a handful of states that provide a limited number of hours annually for parents to attend school-related events and activities for their children. The amount of hours provided varies by state and ranges from 4 hours a year in North Carolina to 40 hours a year in California. Nevada also has a law which makes it unlawful to terminate an employee for using leave to attend a child's school-related activity. These states just offer additional benefits. So even if you do not live in one of the states that has their own family and medical leave laws, you are still covered under FMLA. The Wage and Hour Division of the U.S. Department of Labor is in charge of enforcing FMLA laws. If there is a complaint that an organization is not complying with FMLA laws, then the U.S. Department of Labor will investigate. An employee has 2 years after the alleged violation to file a complaint. If the violation cannot be resolved during the investigation, then the Department of Labor may bring action in court to compel compliance. Employees also have the right to bring a private civil action against an employer for violation. If an employee decides to go that route, they are not required to file a formal complaint with the Department of Labor. The most common way that employers violate FMLA is by terminating employees for taking time off. Workers usually claim that they were not reinstated when they were ready to come back to work, or that they were terminated shortly after returning to work. Some workers have filed complaints about how they were treated once they came back to work. An employer is violating FMLA laws if they do not offer an employee the same or a similar position once they return to work, or if they diminish the employee's pay or responsibilities once they do come back to work. Some employees have alleged that their employers simply refuse to allow them to take time off. This is commonly done by the employer threatening to fire the employee if they use FMLA benefits, or by making it extremely difficult for the employee to get the information that they need in order to file a FMLA claim. If an employer is found guilty of violating FMLA, they may be required to pay damages to the employee, which may include back payment to the employee for lost wages, benefits, etc., payment to the employee for the cost of providing care. For example, if an employee had to pay for nursing care for their parent because they were not granted time off under FMLA to care for them, then the employer would be responsible to pay the employee back for the cost of that care. Reinstatement, promotion, etc. for the employee. Liquidated damages, which is an additional amount of money set by statute paid to the employee for damages they received due to being denied FMLA benefits, and payment of all attorney fees and court costs. Employers should post approved information regarding FMLA benefits in a place where employees will see it. They should also include the information regarding FMLA benefits in their employee handbook. They should also have forms available for employees to fill out and submit stating that they intend to take time off using their FMLA benefits. Employers should also make sure that key employees, for example human resources and department supervisors, are knowledgeable about FMLA benefits so that there is no miscommunication regarding what benefits are available to employees. If employers are unsure or have questions about what they should do in order to be in compliance, they should visit the Department of Labor's website, which includes links to printable posters and forms for their convenience. This concludes my presentation. Thank you for watching. If you have any questions, feel free to reference the links in my references page. Bye!